Good morning. I am Dean Jessica Berg, and I am here to welcome you to our inaugural Practitioner-Focused Conference on United States International Trade Law and Policy. The late 2019 and early 2020 period is shaping up to be particularly consequential to the future of United States international economic law. Trade issues have consistently been in the news since President Trump took on the role of reformer of trade agreements, and to some, or major trade disruptor to others. And Professor Giusolino and Associate Dean Giusolino Collares will be with you for the rest of the conference, leading you through what I hope to be a very interesting discussion of a variety of the issues here that we're facing. Professor Collares is an internationally recognized expert in trade law. Since joining our faculty in 2011, he's made the case that U.S. law schools should reconsider how they prepare students for trade practice. In his class, he teaches both U.S. international trade law and World Trade Organization law, but emphasizes the procedural and administrative aspects of trade practice. He argues that because trade practice involves appearing before the U.S. agencies and subject matter-specific federal courts, law students should be well-versed in the administrative and procedural aspects of U.S. trade law. This unique approach, we hope, differentiates our students and is reflected in the type of conference that he has put together today. A graduate of Cornell Law School who also has a PhD in political economy, Professor Collares is a Brazilian-born naturalized U.S. citizen. He practiced at Dewey Ballantine in Washington, D.C., where he litigated trade cases before federal agencies, federal courts, and NAFTA panels. An accomplished legal scholar, he was recently reappointed by the Office of United Trade Representative to serve on the United States roster of NAFTA Chapter 19, which is the trade panelists. So please welcome Professor Collares, who will introduce our wonderful speakers and the rest of our conference.
Wow, this is a great crowd. Thank you so much for coming, and it's a pleasure to be here. Thank you, Dean Berg, for your very kind words. My name is Giusolino Collares. I teach here. I teach international trade and other like procedural courses, conflicts, and Civ Pro. It's a pleasure to have to be able to bring to Cleveland two federal judges that do trade cases from the Court of International Trade, a number of government officials, and lawyers in both trade practice in D.C. and customs practice throughout the country. This is a unique opportunity, especially given the fact that trade is such a big item on the news every day. Especially now, we have made an effort to invite local counsel, and for Ohio is a big manufacturing state, because these issues that are being decided daily in Washington, D.C. affect more than ever before the lives of so many. So before I go too long, I want to go very fast. I want to introduce the judge. I want to say a couple of words. I want to thank first Judge the Honorable Jennifer Cho Groves, for whom I will introduce you soon, for coming here and giving a talk to us on CIT advocacy. I must recognize also Judge Gordon for helping me both conceive originally of this fourth trade update, and help me also populate, along with Larry Friedman and Amy Porges, the panels. They are amazing. The panelists are truly leading lawyers and experts in the fields of trade and customs law, and I think that the audience will very much appreciate their contribution. Fourth, I would like to thank Luke Tillman, Brendan Saslow, Zach Walker, and Heather Doherty, our case law students who are currently our young alumni in trade. All of them are in DC, and they're all coming for the afternoon alumni panel. I very much appreciate their, paying it forward, and they're helping get our students interested in trade practice at Case. And finally, I would like to express my enormous gratitude to Grunfeld Desiderio, who so kindly gave us a grant that helps defray the cost of this conference. They are definitely a great partner. Of course, we have academic partners, the American Society of International Law, CITBA, the Customs International Trade Bar Association, and the Greater Cleveland International Lawyers Group. Please allow me to introduce Judge Jennifer Cho Groves. She was appointed to the United States Court of International Trade by President Barack Obama in 2016. She's a graduate of Princeton University and has law degrees from Rutgers University and Columbia Law School. And prior to joining the federal bench, Judge Cho Groves was an assistant district attorney in the Manhattan District Attorney's Office under Robert Morgenthau, I believe. That must have been a wonderful experience. She served in the executive office of the President of the United States under two presidents, President George W. Bush and President Barack Obama. Once as a senior director for intellectual property and innovation, and the second time as chair of the Special 301 Committee for the Office of the United States Trade Representative, USTR. Prior to her appointment to the United States Court of International Trade, Judge Cho Groves was in private practice. She has extensive trial court experience, and which is going to be the topic she'll be discussing. Without further ado, help me welcome Judge Cho Groves.
Great. Thank you so much. It's a pleasure to be here. I'd like to thank the Dean and also Professor Collaris for inviting me here. It's a pleasure to be addressing you today. Can I first find out how many people here are practitioners in international trade or customs law? Okay, and how many of you are students? Okay, great. So we have a good mix of both. Okay, so I thought that I would address today some practical tips based on my observations on the bench for the last 3 years about how to be an effective advocate in front of the Court of International Trade. Although our court is very unique, we have an interesting mix of types of arguments in our court. So the majority of the types of cases we hear are appellate oral arguments. A lot of the cases are decided on summary judgment or other dispositive motions. So we will hear oral argument that's a very appellate style based on the record below. However, we also have the ability to do evidentiary trials, so we do bench trials in certain types of cases, in customs cases in particular. We can also do jury trials as well, which happens very infrequently, but it is possible, particularly in penalty cases that come before the court. So we have different types of litigation going on. I think I'll address most of my remarks today towards the appellate style advocacy because that's what we see mostly in our court. But I thought I would talk a little bit about how attorneys can be effective in getting your point across to judges. These tips can also be applied for those students who don't practice in front of the CIT. If you end up in state or federal court, some of these tips can also be applied there. So the first tip that I would like to talk about is the importance of keeping your argument simple. It's very important not to use legalese, and I know the law students may be reading cases that are written in very complex legalese, but that's not what judges really like to see in practice. So in the courtroom, I prefer to have arguments stated in simple language. If it's a complex, particularly in the international trade and customs areas, the law and the facts can be very complicated. So breaking it into very simple issues and simple presentation is really the best thing, and this also goes for a briefing as well. I think the most effective briefs that we see are clear and concise and written in very simple language. I try to reflect that in the opinions that I write. I always tell my law clerks that we're not just writing the opinions for the Federal Circuit, which is where our appeals go, but we're writing it for the lawyers, but we're also writing it for the clients and for the general public. And so some of those people might not be lawyers, particularly the clients who are around the world, who may be reading these decisions and trying to get some guidance on how to approach issues. So I try, if I can, to write in a clear, concise manner as well. Something that I see very often in oral argument is that lawyers come to the podium and they start reading. They start reading their briefs. And I don't think that's an effective way to approach an oral argument. I've already read the briefs before the oral argument starts. I've read all the papers. I've read the evidence that's been presented. And so I'm really looking for this salient points in the argument, not starting from square one and either reading or just giving an entire summary of the case. I would prefer, it's a very valuable, limited time that I have together with the lawyers. I would rather just jump right into the issues and have them address the points right away. And I would say start with your strongest argument, but also don't shy away from the weakest argument. So I would say it's a best practice to start with your strongest foot forward, but if there are some weaknesses in your case, bring those up right at the beginning and start addressing those as well. I think that gives a lot of credibility as well to the attorneys who are arguing. I personally issue questions ahead of oral argument. I think it's helpful to me because I can try to focus the attorneys. I think not all of the judges on my court do this, so it varies from judge to judge. Personally, I like to issue questions because I think it gives the attorneys a very good roadmap of the types of issues that are bothering me. And just so you know, the questions can be very pointed in the written questions that I issue. So even then, I've seen attorneys stand up and start reading their briefs. But in my mind, we've moved past all of that. I just really want to get to the questions that I have. Very often, the questions that I have are, where in the record does it support your position? And when I issue a question or I ask a question in an oral argument to an attorney to say, where in the record do you see the proposition that you're citing? What I'm expecting to see or hoping to see is an actual citation to the record or hand me a document. Because clearly there's an issue in my mind that maybe there's a legal assertion and it's not really clear what the evidence is that you're relying on. So when I ask the question in writing or verbally during an oral argument, if I don't get an answer, if I don't get a citation or I don't get an actual document in the record, I may leap to the conclusion that there is no evidence to support that position. So I think it's in the attorney's best interest to try to answer those types of questions directly. And I'm happy to take any questions as well at the end of my remarks. So let's see. I mentioned earlier that it's important to anticipate weaknesses in your case. I think if you don't address it, certainly your opposing counsel will address it, and I may raise it as well. So it's important and it behooves you to address weaknesses up front. And one other point that I would like to make is we see emotion in court. So when we see attorneys getting very agitated, rolling their eyes, or particularly when their opposing counsel is speaking, sometimes the attorneys will get very emotional. We see all of that. So the judges see it, the law clerks see that. When sometimes attorneys will start whispering to their co-counsel, we can very often hear what you're saying as well. So I would just say try to keep any emotions in check. Also, sometimes we see attorneys, based on questions that the judge asks, they think they're winning, and you see them getting very excited and happy, and that doesn't necessarily mean that they're winning. So just so you know, we're watching all of that as the oral arguments are proceeding. Um, Regarding motions for temporary restraining orders or for preliminary injunctions, we often see those types of motions made, I always invite hearings to be held on TROs or preliminary injunctions. Very often, what you see as evidence, particularly for the issue of irreparable harm, is that you'll see an affidavit from a lawyer who's been informed by a client as to the irreparable harm, and they submit that as their proof for the application for a TRO or a PI. And I would say that that is not necessarily the strongest evidence that can be provided. What I usually invite is I will hold a hearing and I invite the attorneys to bring in their clients and fact witnesses who can testify in person about the effects that their company will face if they don't get a TRO or a PI issued. And I think that the testimony in person of a live, credible witness can be much more persuasive than a mere declaration from a lawyer who's been informed by a client. So I'm sometimes surprised at how infrequently people bring their clients in to testify about the irreparable harm, because as you know, it's an extraordinary form of relief, and those are the types of things that we're looking for as a judge in deciding whether to issue a TRO or a PI. Likewise, on summary judgment, a lot of times we receive competing expert reports, and there are declarations from different fact witnesses or particularly experts. The parties may tell us that that the case can be decided on undisputed material facts, but when you've got competing expert reports, I think sometimes it's difficult to judge the credibility. It's almost impossible to judge the credibility, in my mind, of competing experts. So in those situations, I think sometimes summary judgment is not possible to grant at that stage, and you really need to go to a trial to see the testimony of the experts in particular and assess the credibility and then make a decision. So that's something that I've been doing in recent cases, and it's merely because I think on paper it's very difficult to judge the credibility of competing experts. One thing I'll mention to the young lawyers and to the aspiring students in the room is that I can't say strongly enough how important it is to speak in a loud and clear voice in the courtroom. I've seen many young attorneys come in and they speak very quickly. And granted, we're in New York, so there's a lot of quick-talking New Yorkers that appear in front of us, but it's so important, and it's not natural, I'll tell you, to have a courtroom voice. It's something that is learned and something that you have to get comfortable with. You're speaking more slowly and more at a volume that is not normal in conversation, but it's very important to do in court. Because if you don't, you'll have a muddled record below, or you'll upset the stenographers if they're in the courtroom trying to take down every word you're saying. And finally, I think one thing that's very important in my courtroom is to have everyone be courteous to one another and act in a very professional manner. If people are giving a hard time to the courtroom deputies, for example, we hear about that. If I don't like to see people being rude to opposing counsel or making arguments personal, and I've seen all of that in my time on the bench. So that's very important to me. And I am happy to take any questions.
Thank you very much, Judge. I need to, before I ask, I use my privilege of being the host and ask my one or couple of questions to the judge before I turn it to you guys. I want to inform that this portion of the program is being live streamed, but once this portion of the program, the one-on-one and the Q&A, and we go into a break, after we come back, We're no longer going to be recorded to encourage candor and to make sure that our guests feel comfortable about what they're going to say. And so be candid. All right. So, Judge, on the keep it simple point you made, I recall being limited to 25 pages on a couple of ITC proceedings I participated, injury proceedings, and I remember how difficult it was to basically pack your injury case into 25 pages, and how we made some artful use of appendices, which were massive. But do you have page number limits in your briefs? Do CIT judges adopt those? And I also asked the question because I wanted to hear your reaction. In a big criticism of W2 opinion reports is the size of some of these. I think in the aircraft case, it's over 900 pages. I mean, I'm sure it's over 900 pages. It's enormous. And so definitely in that case, the W2 arbitrators are not keeping it simple, members of the appellate body in that case. So do you impose limits? Do your colleagues impose limits? Do you ever do that?
So yes, we do have page limits. They're in the CIT rules, and then the judges are at liberty to either expand or contract those page limits per chambers. I often do get requests to add extra pages, and I usually grant those just because I feel that if the parties have thought it through and they feel that they really can't express what they need to express within the page limits, then I usually grant that to go beyond. But within reason. I mean, I would never encourage a several hundred page submission, but for a brief in particular. But the appendices that we receive are many thousands of pages on a normal basis. So I think generally it's important, I think, to keep the cases narrowly focused from both the attorney's perspective as well as from the court's perspective. When I think about the cases, I'm not interested in writing opinions that are very broad and far-reaching. I think that we need to focus on the narrow issues that are presented in that particular case. And again, for most of these cases, they're on appeal from the administrative proceedings. So I think on the appeal, the issues should be narrowly focused, just by definition. So it's different than the proceeding below, where you would have more leeway, I would think, to develop that record. So for us, it's really a question of tailoring the issues in a very narrow way at CIT.
I like what you said about, when you have appeals from administrative proceedings, the record is well built, and so you want to narrow things down. It's absolutely the case. So on this issue of addressing the weaknesses in your case that you point out, as you know, not every proceeding before the court has the benefit of having a fully developed record. In the case of trade remedies, that's an easy. I mean, the record is fairly well developed. There are preliminary determinations. There are issues and decision memoranda, and there are hearings, and there are significant amount of briefing. But on certain, for instance, not to pick on customs, but on certain customs proceedings, let's say the importer goes directly to the court, maybe after filing a protest, and the protest doesn't get an answer, for instance. So how does that affect your job as a judge in terms of not having, a fully developed record, and how does that change your analysis and your expectations in terms of people, including the government, addressing weaknesses in their cases?
Well, with respect to customs, after the filing of a protest and the filing of a complaint, the parties do get to do discovery. So that is something that I try to stay involved with as much as it's helpful to the parties to be able to get full discovery, to develop that record. It's a different standard of review, of course, in terms of what we're looking at, but in the customs side, it's really up to the parties to develop that record during discovery through the document production or interrogatories or deposition phases, and then to provide that information to the court when they're advocating for themselves.
Thank you. I'd like to open questions to the audience. I have asked a volunteer to use a microphone. Where is the microphone? There? Oh, you already have it. Thank you. So please feel free to ask questions to Judge Cho Groves.
Back there.
There's a question back
Okay.
there.
No. Oh, here. Okay.
Larry here. Thank you.
I'm never shy. Thanks for being here, Judge. Appreciate it and the opportunity to ask questions. You mentioned that in TRO and PI proceedings that you think it's helpful to have the client in court to discuss the issues. Given the national jurisdiction of the court, I'm wondering if you are willing to comment on your perception of judging credibility and judging credibility in person versus video conferencing and telephone, because I know the court does a lot of electronic communications these days.
Yeah, I mean, that's a good question. I think for me personally, this is not speaking on behalf of my other colleagues, but for me personally, I think it's important to judge, when you're judging the credibility of a witness, it's important to do that in person, I think. You just get a better sense of a person in terms of their candor, whether they are hesitating. You just get a sense in person that you can't, I think, you certainly can't get on the telephone, and it may be even difficult to do by video conference. I've actually not done, I'm trying to think, I don't think I've done any TRO or PI hearings where witnesses have testified by video. I think even when the witnesses are from all over the country, they've flown in generally to New York to testify. I also think if it's that critical, I mean, not necessarily, but if they're really alleging some irreparable harm where they're asking the court to issue a TRO or a PI, you would think it would be important enough for at least one person from that company to come into court and testify about why it's important to them and why they really think. And having said that, it doesn't mean that a TRO or a PI would not issue if there's no witness. I just think that it can be a very persuasive tool if you do have a witness who will come in and testify about the proposed harm that would happen to that company if they don't get their TRO or PI issued. But it's not impossible to do it without having a witness in person either. And I understand sometimes there's cost involved and obviously travel. So I wouldn't say it would be impossible by video, for example, but it's certainly persuasive to have someone in person.
You could say your name too before you ask your question. It would be nice.
Hi, I'm Steve Petrus, Director of the Cox Center. I have a question. Just in your experience as a judge on the bench, what has been your most interesting case, and which legal issues do you find to be the most interesting?
Well, now you've caught me. I'm trying not to talk about my cases, so I'm trying to be forthcoming without talking about my actual cases.
Which were being live streamed, so you know.
Yes. So one thing that I find very fascinating at CIT is the jurisdictional interplay between CIT and the other courts. So I've had some cases that are just very, very fascinating in terms of whether the appropriate venue is, for example, the ITC or federal district court or CIT or the patent and trademark office and/or all of the above. I've had cases where the parties have been litigating simultaneously in all of those different jurisdictions, as well as the federal circuit, and in federal district courts around the country on essentially the same legal issue. So I find those cases to be very interesting and nuanced in terms of jurisdiction. That's one area that's quite interesting, I think.
Hi, Richard Wortman. So I'm an old-fashioned customs lawyer, so I'm going to ask sort of a three-part question. And first is, how do you approach, philosophically, customs cases versus trade cases? Because I think that they're very different worlds, at least from my point of view. And how does both the presumption of correctness of the government's activity and/or Chevron defense play into that? And I know that can take you in 12 directions, but I thought it'd be a sort of an interesting piece to hear about. Thank you.
Okay, thank you. Well, so I would agree with you that customs and trade are two different worlds. There are different legal standards that are applied from the perspective of the court. From a factual standpoint, in the customs side, it's de novo, and as I mentioned, we can do the trials, evidentiary trials, and you're developing the record as the litigation is proceeding through CIT, which is very different than on the trade side, where the record is already developed. It is self-contained, and you're looking at you're reviewing the decisions of the administrative agency below. So they are two very different worlds. You really can't compare the approach because they're just and from an advocacy standpoint, they're two different skill sets, really. I think where on the trade side, it's really an appellate advocacy exercise, and often we do see the arguments about deference under Chevron to the agency, whereas on the customs side, it's de novo, and where the court is making findings of fact and applying that to the law, and it's just a very different skill set. And an entirely different approach. So I don't know if that answers your question, but I do agree with you that they're two different worlds. Yeah.
No one has a question? I have one.
Okay.
Okay, so, and obviously, this is always limited to the extent you can talk about not specific cases, but issues but I'm more interested in your experience as a judge. The CIT, as everyone knows, is an Article III court that has national jurisdiction. It's a court of first resort, and it hears cases. I mean, it sits in New York, but the judges from time to time hear cases in other parts of the country. I also know, which is another item of interest, I mean, you may have noticed when you were in law school that you would see like 3 judge appellate panels, and you'd see one judge that was not from that court. So that happens with CIT judges too. They serve by designation. I wanted to ask 2 questions about that, I mean, briefly, and to the extent that you can comment. Explain how this happened, and to the extent you can talk about cases, what has been your experience, doing, serving by designation in different circuits in different parts of the country.
Yeah, I'm happy to talk about that. I have sat by designation several times now, and what that means essentially is that CIT judges are invited essentially to sit in different courts. So, for example, I just sat recently on the Second Circuit, And then I've sat several times on the Ninth Circuit. And so what that means is there are 2 judges generally from the, let's say, the Ninth Circuit, and then I would be the 3rd judge. But I would be designated as an equal panelist on that 3-judge panel for the Ninth Circuit or the Second Circuit.
And who designates you? Is that the chief judge?
It's the Chief Judge of the Supreme Court. So Chief Justice Roberts has to designate that and sign off on that. I find it fascinating. I very much enjoy it because also it's a different, obviously they have a different substantive caseload there. So when I sit on the Ninth Circuit or the Second Circuit, there's a lot of different kinds of cases. So it could be criminal, it could be immigration, class action, ERISA, securities fraud, constitutional issues. It can almost be anything. Personal injury on a federal property, workers' compensation, employment discrimination under Title VII. It can literally be anything. So I find that to be fascinating. Also, in my experience, I grew up as a litigator, essentially, in state and federal court. So I very much enjoy that process and the variety of cases as well. Not to say I don't love international trade and customs cases, which I do, but I think from a personal perspective, for me, it's fun to hear different types of cases. And I think for my law clerks especially, it's a very positive experience because my law clerks, they come in to CIT doing a clerkship for 1 year or 2 years doing international trade and customs work, but they can also get a mini clerkship on the Second Circuit or the Ninth Circuit, and they get to do the same work that a Ninth Circuit law clerk would do on the Court of Appeals on those cases. And so, and sometimes there are writing assignments that come out of those sittings by designation. So we would write an opinion on, it could be on any issue, and I think that's a great experience for law clerks. And also I think it's interesting to litigate or to sit with litigators around the country because you see sometimes just wonderful litigators from all over, and particularly in the Ninth Circuit and the Second Circuit, some of the cases are very big, so you get top-notch litigators, and I think from a law clerk's perspective, that's invaluable to see that type of argument as well. But I find the designation process to be a lot of fun, so that's why I do it. Yeah.
Can I just talk? I've got a litigator's voice.
Great.
Say your name first, please.
Beg your pardon? So if you are not called up to the circuit courts because of your expertise in international trade law, why are you called up? What creates the vacancy that makes you have to be on that panel?
Yeah, in fact, we would never be called up for international trade expertise on those panels because we at CIT we have exclusive jurisdiction over international trade matters. So we wouldn't. The international trade is the one thing that would never appear in front of us on the Ninth Circuit or another circuit. So usually it's just a need in those circuits where they have a lot of vacancies and they just need extra judges. So they invite, it's not just CIT, but they invite judges from around the country to come out there and sit. So certain circuits are more in need, I think, of filling those spaces on their panels. Yeah.
So I take it there is a problem now with appellate judgeships not being fully filled. Is that correct?
That is correct, yes. So I think it's probably a combination of they have still a high volume of cases that need to be heard, and they have multiple vacancies, and they still need to have panels move those cases forward. And so they essentially invite visitors to come, visiting judges to come. So it can really be any Article III judge who could sit. And so we've been, judges on my court are fortunate enough to be invited sometimes to sit. And it's not just those circuits, but it's any circuit that would have that same situation where they have a high volume of cases and not enough Court of Appeals judges.
One last question,
Yeah.
so I can clarify this in my head. Is this, you've obviously been in government a very long time, is this a recent phenomenon, or has this been true from the entire scope of your federal practice?
Which part?
That the appellate judgeships are not filled, that the courts are thin on personnel. Is that a recent phenomenon, or has this always been true?
Well, I think that's just historical. I think that it always varies depending on the number of judges who are retiring and the rate at which those vacancies are filled as well. So I think it ebbs and flows just depending on the personnel and political situation. So
I would add that the president.
I don't know if Judge Gordon, yeah.
It's not for appeals. I mean, there are district court judges and chief judges who sit by designation around the country as district court judges. One of our senior judge colleagues just came back from a couple of weeks stint in New Mexico because they're short judges and they've got a lot of cases at the border and they needed some extra help just because of volume. This is a historical process that, I've been at the court for almost 40 years, and for most of that time, one judge or another on our court is set by designation somewhere, either as a Court of Appeals judge or a district court judge. So it's not something new, and a lot of times, well, it's done by active judges, senior judges, those active judges who've reached a point in time in their life where they opt for senior status. There are a lot of judges who are in senior status who are doing these, what I'll call extra service filling jobs.
And I would add to that, that was Judge Gordon, by the way. I would add to that the last, who remembers here, I know the date, but the last time when the jurisdictional amount of in excess of $75,000 was changed? What year? 1980. So, I mean, the federal courts are packed. Their dockets are packed. And we know we have a historical problem in the Ninth Circuit, that it's a giant circuit, and it needs to be split. And there's just no political consensus in how to divide it. And you would need to call many more judges to the bench. And I can give an example too. Also, the President Trump, when he took over, there were over, I think, 141 vacancies in federal courts, district court and appellate courts as well. And he's already nominated 151, I think. And there are still more. I think there are more than 30 vacancies. So more have become open. So even I think that if President Trump fills all these vacancies, you would still have this phenomenon of service of judges serving, not only CAT judges, district court judges everywhere, serving by designation in different parts of the country, because the dockets are so full, and the issue of the jurisdictional amount is still very contentious.
And there's always an attrition issue with judges retiring or going senior. So, and that's just always going to happen. So it's difficult to come to a point in time when all the vacancies in the United States would be full and there would be plenty of judges to go around. Because there's just such a high volume of cases around the country. And I've also sat by designation in the district court as well. So I've sat in the Southern District of New York on multiple cases. Again, it's exercising a different part of the brain, in if you will, to do jury trials or other kinds of cases as well, which is just, I think, again, interesting for the law clerks, interesting for me, but it's all optional. This is all optional, so no judge has to do this, and it's just extracurricular work, and we're not paid anything extra for it. People can turn down the invitations if they so choose. Any other
More
questions?
questions? Any more questions from a student who? No? All right.
Oh, there's a
yes, we
question.
have Lisa Wang, my former colleague.
Thank you. I didn't even have to say my name. I'm going to ask a question I think that students want to know. You talked a lot about your law clerks, about the process perhaps of what you look for in a law clerk, timelines, things like that.
Sure. Well, law clerks are extremely important to the workings of a chamber. What I look for in law clerks are strong writers, strong legal analysis, and a willingness to learn. And I think it's a fantastic experience for students, especially if they want to go into litigation. Whether that's at the trial level or appellate, I think it's a wonderful experience to be able to be in the courtroom and see all these fine litigators come in front of us and see how they present their arguments. And to be reading all the briefs, it's a fantastic experience as a student to be able to do that. And I think it can also be very beneficial when they're trying to figure out if they want to go into international trade or customs law, perhaps as a profession. If they come and they clerk for a year and they can really dive deep and see what the substantive area of the law is, sometimes they come out just very passionate and they know exactly what they want to do. Sometimes they come out saying, I think I really don't want to do international trade and customs, which I think is also a valid conclusion. But they've seen it, at least. They, instead of just theoretically thinking about it, they have actually, been involved in cases, and they've done research very deeply. And then, if for whatever reason, if they decide this is not their cup of tea, that's a valid conclusion to come out of a clerkship and say, I'd much rather do employment litigation or something else, which is fine. But so I would encourage all the law students who are here to apply for clerkships. And those vary from judge to judge on the timing. I have 3 positions for clerks available, and they tend to, they don't start at any one point in the year. A lot of judges start them in September, but it just depends on schedules. So sometimes they vary, and they'll start in the middle of a year or at the beginning of a calendar year, for example. I tend to prefer law clerks who have some experience and some level of maturity as well. But I've also hired them straight out of school as well. So I highly encourage it to any of the students who are here.
Thank you. With that said, we will conclude our initial program, part of the program here. We would like to be a little early because the second panel is going to have 4 panelists instead of 3, and the first panel has a lot of issues, very interesting issues, I think, which the audience would love to engage. So let's have a break now, and let's come back at 9:30. 9:30. Okay? Thank you.
You're welcome. My pleasure.